Hello, my name is Robert Goodwin, and welcome to Law on the Line. I'd like to welcome my guest for this episode, Tim McGuffin. Did I say that correctly?
You certainly did, Bob.
All right, thank you. And Tim is a lawyer who practices family law in Monmouth County, Ocean, New Jersey. And he's been practicing for, 25, 30 more?
A little more than that.
A little more than that. And our topic, and Tim, most importantly, is the immediate past president of the New Jersey State Bar Association. And I welcome you aboard to Law on the Line, and I'm looking forward to the next half hour of a very interesting area.
Happy to be here, Bob.
Thank you. And I know that how I became acquainted with this topic is directly through you, and it was through a ICL course about mental health diversion that I saw being advertised, and I, among the lawyers, and I said to myself, you would be a fantastic guest to talk about a program that many lawyers don't know about, including me. I'm a family lawyer primarily, was a prosecutor, and I retired just before this law went into effect. Mm-hmm. So Tim, when did the new law called Mental Health Diversion Court began, and what is the genesis of that?
Well, when it's been floating around for a couple of years in the legislature. Senator Ruiz and Senator Cunningham were two of the main proponents. For me, April of 2023, the Board of Trustees, before I became president of the State Bar in May of 2023, the Board of Trustees created a task force on trying to get this over the goal line because it had gone through several legislative sessions. So we put our weight behind it and worked with Senator Ruiz and other stakeholders. As lucky Irishman that I am, literally within a month of me becoming president of the New Jersey State Bar Association, it got a Senate hearing, got through the Senate, had a second reading, got through the Assembly, where it sat for a considerable period of time, I think mostly due to the fact that everybody was up for election in November of that year. So the governor didn't want to sign it because it is a little controversial bill. There's some Republicans who feel that maybe it's a get-out-of-jail-free card, but it was sort of held till after the election. Governor Murphy signed it into law in December of last year, and July 1st, 7 days ago, is when it's supposed to roll out, and that's going to be with three different South, Central, and Northern regional courts that are going to be doing this with the AOC. But the most important thing, the AOC and the Attorney General's office.
AOC being the Administrative Office of the courts.
Yes. And the most important thing is it's got funding. That was the holdup. And why it all occurred in June was, as you may be familiar, that's when the budget's done. So in
June 30th is the end of the fiscal year, and July 1st is the beginning.
Right. So they were able to get it all together to get the funding for it, and hopefully this year we're going to start seeing the fruits of it. Although there's been other counties that have been doing this for quite a period of time. There's Essex, Monmouth, Union, Morris, Middlesex, Ocean County. One of the great things about when I got involved with this was to be able to go around the state and see all these, like I like to call them, little points of light. And they've really been run by one very passionate person, passionate prosecutor, passionate lawyer, maybe a passionate mental health professional who's got the ear of the prosecutor and have made these programs work.
In each county or in the counties where they were?
Counties where they were. And so, some counties, it's not there yet, and hopefully they will get there. I mean, the goal of this statute is to make this statewide. They have calculated it's going to cost about $1 million a year per vicinage. But when you think about the amount of money that's saved on recidivism, it's really a long-term fiscal win. And
with respect to what we call a diversion court, and this specifically being mental health diversion, for those folks that are not familiar with diversionary programs that already exist, what distinguishes this program from, for example, pretrial intervention or perhaps even drug court, maybe not totally analogous, but explain a diversion program in the process of a criminal prosecution?
Well, I think the key element to this particular program is it's very prosecutor driven. And the reality of why, and that's been controversial, why I like that is who has hands on that client, that defendant, right off the bat. It's the law enforcement. It's the prosecutor's office. They have the first real look at this person, and with the proper training with law enforcement and proper training with the intake people at the prosecutor's office, that gets people in the right avenue. As you know, as a prosecutor and as a municipal court judge for 23 years, you see a lot of mental health issues and substance abuse issues.
Let me just interject. You were a prosecutor at the municipal court level, I believe, and I know you were a municipal court judge for many years. So you're saying it begins at the municipal level, almost begins at the police station upon the arrest.
Begins at the police station.
So explain the process.
Well, somebody comes in and if there's an obvious mental health issue, which can be discernible by the law enforcement officer, and there's lots of training, CIT training, crisis intervention training, to find out if somebody needs immediately to go to a hospital, if they need, they're in crisis and they need to go and get some help right away, or whether or not it should just be tagged, say, listen, this person, there's something that's just not right. Maybe their medication's off. Maybe they're not taking medication. Maybe they should be taking medication. Whole myriad of possibilities are there, and it all starts with law enforcement, and then it starts with the prosecutor's office. But a big component of this process is it's collaborative in nature. It's not adversarial. Once you're in the program, it's not prosecutor against defense lawyer. It's the prosecutor, the defense lawyer, the judge, the mental health professionals, the social workers, all working together to come up with an answer to allow for this person who's found themselves in the criminal justice system an avenue to get out to be a tax-paying member of society and have a better quality of life.
And without necessarily a criminal conviction attached to it.
Absolutely.
So when does the initial process, if it begins almost from arrest, when there's an evaluation done and may be very informal, when does it become a more formal process where and for the purposes of references here, there is, I brought some forms with us, a mental health diversion program referral form, which I know that you're very familiar with, and we'll show it on the screen at the end of the show. But tell me about that, and how does it get to a particular prosecutor on the county level and/or a judge? Is there like a drug court judge, or is there?
There's a drug court judge and there's a recovery court judge. It's now recovery court. Now they don't call it drug court anymore. And then there's the mental health diversion court. There's also the veterans diversionary courts, which have had some success but need some work. And I think this mental health diversion court really creates a difference. A lot deals with a lot of people who are in this program are represented by the public defender's office. So a good deal of outreach has been done with the public defender's office to make sure their public defenders are aware when they have that initial intake, if there's an issue there, that this is something that they have to look into. There's an application process. There is definitely people in the counties that have these programs that are the point people that you will get referred to make the application. You have to get documents, medical records. There has to be a diagnosable issue. It's not just somebody's off. There's got to be something where you are able to go and show that there is some type of mental health illness that is diagnosable and identifiable that's going to fit you into the program. You
made a reference in our little chat beforehand about a DSM, or certified mental illness, which allows you to get into the program. Is that accurate?
And some of the other issues that you have too are competency. Okay, some people mix up, okay, I've got somebody with a mental illness and somebody who's incompetent to stand trial. And sometimes when that person is first introduced to the criminal justice system shortly after the arrest, or maybe they're being detained, there may be competency issues. You have to be competent to participate in this program. If the mental illness is such a degree that you're incompetent to either assist yourself in your defense, or you're just incompetent to stand trial, you're not going to be eligible for this program. So there's those eligibility guidelines that are going to be looked at by the prosecutor's office to make sure it's an eligible crime. It's usually a 3rd or 4th degree offense. Sometimes it can be higher than that. It should be a nonviolent offense. There's some violence. Megan's Law, arson are excludable. That the prosecutors can't utilize.
Meaning sexual
Yep.
offenses involving sexual
Yep.
contact. Or,
You know, so anything's a second-degree crime. A prosecutor on a case-by-case basis can review them and bring the folks into the program if they believe it's necessary. Rarely does it occur on a first-degree crime. And a lot of this you'll find, and you'll see, you were a municipal prosecutor, is that there's a lot of people who come through the door all the time that I see that weren't necessarily bad people. They either had some type of mental illness or they had a chemical addiction and economic, lower socioeconomic status where, just forcing them into some kind of criminal conduct without having their mental health diagnosed. And I was very fortunate in my town that we would have
Ocean.
Yeah, Ocean Township. We had someone there at every session. So if there was somebody that was an issue, I could refer them for an intake right there in court. They would go meet with the mental health professional, and they would schedule, whatever the next step would be. But that was on the municipal court level. It was very limited as to what authority you have.
And this is before the state law was enacted, and so you were doing this on a very local level.
Monmouth County is doing it is doing a lot on the municipal court level, reaching out to the municipal court level because there's no drug court in municipal courts, a recovery court. So it's the outreach is there, and it's just the people who get involved in this find that it's very fruitful and helpful, and it's also cost effective.
So is it correct that there's almost two systems, one for indictable offenses that go up to the county and then more on an ad hoc basis, a municipal court process?
Absolutely.
But not all municipal courts adopt that protocol or that paradigm. Is that accurate?
That's very accurate, and plus a lot of municipal courts just don't have the resources. Towns like Piscataway and Ocean Township, you've got some resources where you're going to, you're going to be able to hire somebody to come in and work part-time and go to court sessions and meet with people and have counseling programs that are at low or no cost.
And educate the municipal court judges and the municipal court prosecutors. But getting back to the program that's now statewide, now effective just a week
1st.
ago, literally, that this present law, you described it, came through legislation, and it was really it was a hard sell, wasn't it, for proponents of this law, including the state bar?
It was a hard sell, but Essex County and Union County have had it for the longest period of time. Union County, I think, for the longest. Essex County's had a program for 12 years, which basically the prosecutor pulled prosecutors out of other assignments and was able to get some community outreach, to get the mental health professionals, to get some funding to make this all happen. Those programs showed a tremendous amount of promise with a very low recidivism rate. And I think it was when Senator Ruiz in early 2023 actually went and saw how the court worked in Essex County and saw the model that they had there, which has been working well for about 10 years. I think that really was the impetus to say, okay, this is something that we can do. And the question as to, going statewide, Monmouth or New Jersey's 21 different counties, right? And some of them are a little different than others. In our northwestern regions, southern regions, different philosophies. So I think when we have the program in place in these pilot counties, people are going to be able to see.
Is it still a pilot program, or has it been adopted statewide and in effect in all of the 21 counties?
Not all 21 counties. There's a south, a central, and a north region that the AOC and the Administrative Office of the Courts and the Attorney General's office are supposed to determine, which I think is going to happen very soon, and that they are going to have these courts that are going to be the pilot programs for really trying to create some uniformity. There hasn't been uniformity. There's some in Ocean County. They were very hands-on right when somebody was arrested. They had an outreach with their law enforcement officers. If you've got a problem, call this person. And 2 o'clock in the morning, and I think this was the assistant prosecutor had a nursing background, so it was perfect for that spot to understand the diagnosis and what the issues are. So there's it's been different ways that it's been handled, and I think the idea is to create this uniformity. So the law itself does say it is the goal of this law to go statewide. And I think the costs are very reasonable when you think about $1 million a year in vicinage. When you think about just the costs, immediate costs of saving money with people that aren't being incarcerated, that might otherwise be incarcerated.
Do counties have the discretion under the statute to opt out of the program? I mean, a goal is fine if I agree with the goal.
Well, I don't think they're going to have an opportunity to opt out.
They can't.
The counties are, I mean,
Can
we have a unified court system now. Chief Justice is the head of the courts, and the AOC run the court. They're on board with this program. They've been doing their own for a while, knowing that this was coming. So it's here to stay, barring some hiccups. But it's been around for a long time, and you haven't heard stories about this person who was in this diversionary program did something heinous. It's a good program. There are areas that can be fine-tuned, but I think overall the amount of money saved and the people that are allowed to have a more fruitful life, who deserve it. Mahatma Gandhi said, a society is judged by how they treat their most vulnerable people, and we have our mental health population is really some of our most vulnerable.
So what would the protocol that a criminal defendant would find themselves, and not in the municipal level, not at the county level, it's an indictable offense, one that's eligible for the program, how would the initiator would be his defense attorney? Would it be the prosecutor that's pre-screening some of these complaints that are coming out of the various municipalities? It comes through a municipality. That's where the original charge mostly would come from. It comes from New Brunswick
Sure.
or from Ocean, and officer writes up a complaint, and then it has to go up to a grand jury. At what point does the county look at it? Is it the prosecutor that gets it before the public defender, or it depends?
Could be both ways, but it's predominantly the public defenders, and that's why we spent a lot of time working with Public Defender Salidi, who's taken over as the head public defender in New Jersey. He's doing a great job, is having their public defenders recognize this, and there's training that goes on. In Essex County, and I'm very familiar with Essex County because my daughter's, full disclosure, she's an Essex County assistant prosecutor in that court. Right. So I see the inner workings, and the public defender's office is vitally important because they need to know the proper screening of individuals who may fit into this profile, and also to get the information that you need. Just imagine you've got somebody who's been involved in the criminal justice system, not doing so well, isn't on their medication. It's going to be hard for them to help you get the records that you need to show that diagnosis, to show that you're eligible for the program. So there's a lot of work that goes on.
What if you are a recidivist and you have a prior criminal history, perhaps shoplifting related to mental illness, maybe severe depression, maybe some drug dependency? You have a record. Are you eligible for the program?
Absolutely, and that's probably most of the clients are
Correct.
Fit in that role because they get to a point. There was a study done that 65 to 70% of juveniles that are incarcerated or detained have some type of diagnosable mental illness, and the clock turns to 18 and they're just let out, and the funding and the care that they're going to need is lost, and then they just get into the criminal justice system as an adult, and things unravel
very quickly too.
Very quickly, and the issue is really just trying to catch people when you can, to get them on a path that hopefully will stick for them. And it doesn't work for everyone, and the program has its checks and balances. You can get thrown out of the program if you do not comply with very strict supervision. So
even though I may have a criminal record, let's say, for example, shoplifting, and then it turned into another offense for larceny, now I have a fourth degree conviction, And now there's another incident that now diagnosed through this program. Give me the protocol there and what would happen with that charge if I successfully or defendant successfully completes that program.
Well, the whole goal is to get you out of the system. If you've had a mental health problem that was diagnosable before you committed the crime and you're able to successfully complete this period of adjustment, you're going to walk out of there with no offense, and you're going to walk out with an expungement. The idea is not
as to that charge.
As to that charge, the idea is to avoid the obstacles and the hurdles that unfortunately the criminal justice system sometimes puts in the way of people to rehabilitate themselves because of a criminal record that they have that won't allow them to get meaningful employment, which then gets them back into the cycle of some criminality to support themselves or their families.
You spoke before the Assembly or the Senate?
Senate.
The Senate. Mm-hmm. And when Judge Pinocchio, Senator Joe Pinocchio, who was opposed to the law, said mm-hmm. that all you're doing is giving someone a get out of jail free card, quote, get out of jail free card, and saying that it was at one time the judge and jury that was to decide the outcome. And now it's the sole discretion of the prosecutor. How did you counter that, and were you able to convince him otherwise?
I don't think I convinced him on the vote that day, but I think I convinced him when I pointed out that our system is very much prosecutorial driven. Prosecutors have an amazing amount of discretion. Bob, I don't know if you had the same thought. When I first became a prosecutor, I'm like, well, what book do I go to decide whether I downgrade this or if I just recommend a dismissal? And you realize it's you follow the law, you follow your gut. Does this person deserve a break? Is there an avenue to get this person rehabilitated or to create that appropriate deterrence? So, you know, prosecutors already decide whether or not it's going to be, I'm going to charge them with murder, or I'm going to charge them with manslaughter, or I'm not going to charge at all. So prosecutors have always been the gatekeepers to the courthouse. But they misconstrued this particular bill because the judge is a major part of the team. Okay, the judge is there to make sure that this person follows the rules, complies with the requirements of the program, but it's really very different than any other court. They don't do things traditionally. The judge doesn't sit up on the bench. The judge is down there. If we were in court right now, there'd be somebody sitting there, prosecutor, defense attorney, mental health professional.
You used the word collaborative before.
Collaborative, absolutely. And that's the whole idea behind it. Everybody is working for a team approach to help this individual have the best chance for their best life.
What's the time frame from, let's say, diversion, initial recommendation for diversion, entry into the program, to, let's say, the conclusion of the process and a determination that there should be a deferment or deferral and no conviction?
A year or 2 years, depending on the cooperativeness and whether or not the the defendant is buying into the program, which is vitally important. But generally, I think on the outside it's 2 years the most, but it's minimum a year, maximum 2 years for the most part.
What does it cost a criminal defendant anything to get into this kind of program?
No.
Who pays for the social workers, psychologists, other counselors, whether it be substance abuse, alcohol, whatever it might be that this person needs, and obviously mental health issues? Mm-hmm. Who pays for these professionals?
You and me, Bob.
Okay,
taxpayers pay for it, but it's compared to the cost of incarcerating someone, compared to the cost of criminally prosecuting someone. It's really a no-brainer when it comes to the amount of cost savings to the taxpayers. People who are getting into these programs. Most of them, really want the help. And the programs are built upon collaboration. It's built on respect. A lot of people who have mental health problems, lower socioeconomic individuals, they find that it's not just the program, it's the respect that they get as a human being in a program, that people care about them who are people in authority, like judges, like prosecutors, like defense lawyers. And that's kind of really the key to the program, is people see that they're getting respect from people that, that they respect, and that they can, move forward. Just
a question of proper usage. Has this program superseded a drug court, or they run in tandem?
They run in tandem. It's recovery court.
Right. That's recovery court.
Recovery court,
right.
All right. And they're in every county. I mean, the stats I have for recovery court, and one of the things that I think is really interesting is 1989, we didn't have drug courts, recovery courts.
Correct.
Now we have 3,700.
In the United States.
In the United States. 1997, that was the first time there was a mental health diversion court, and we now have 300. The statistics, once you build on them and you see that and you get the data driven showing the recidivism rate is substantially lower than someone who was put on probation, incarcerated, that's just not getting them what they need, because a lot of what these folks need is what they call wraparound services. All right, so that's getting to housing, employment, some type of counseling to allow them to deal with the day-to-day stresses. And now, even more than ever, you have, I call it PPSD, post-pandemic stress disorder. I mean, everybody's wound a little tight now. And the people with mental health problems, it's just exacerbated.
And Tim, if somebody successfully completes the program, are any of these services available to a graduate, if you will?
Mm-hmm. And it's interesting you say graduate, because it's a very important part of the program. There's the graduation, there's a ceremony, there's pomp and circumstance associated with it, because it's a huge achievement for these people. What my daughter likes to tell me, and the people who work with her in her court, you have to approach these folks where they are. You can't expect them to come where you are in the court system and acclimate themselves. You have to get down to where they are, where their life is. Where am I sleeping tonight? Do I have money for medication? Am I going to be able to see a doctor who's going to prescribe me medication? A lot of this stuff that's can I go shopping? Can I get on the bus to get to court today? Some of these are major achievements, and they have big parties when somebody took the bus and got themselves to where they needed to go by themselves.
Graduation is a very meaningful term.
It is a very meaningful term.
Tim, I got the 30-second warning, and now we're about 20 seconds left. Are most county prosecutors who are appointed on board?
I believe so, yes.
Good.
All the ones that I've talked to.
Now, last 15 seconds, attorney wellness. Mm-hmm. Just finish up on that thought about what magic words for attorneys who are practicing in this post-COVID environment.
Take care of yourself. Geraldine Lawrence was the president before me, started something called Putting Lawyers First, did a great job of getting the word out there. We started a members assistance program where we have free counseling for every member and their household members. It's been in operation for a year. We've had over 2,200 consults that have gone through there, which is a significant number for 16,000 members. And our world is stressful. Legal lawyers, stressful. But if you're a member of the New Jersey State Bar Association, you can contact the Member Assistance Program. There's unlimited virtual counseling and confidential virtual counseling. And there's 3 in-person counseling sessions you can have, and they will actually try to set you up with who your insurance company is. So if you want more counseling, you can do that afterwards.
Well, Tim, I know that without anybody even pointing the finger at me, we're out of time.
Well, Bob, that was a quick 30 minutes.
And that is the quickest 30 minutes, I think, that I've experienced on this show.
Yeah.
And I want to thank you so much, and being a guest on Law on the Line. It was really for me, very informative.